Welcome everybody to our Sprintlaw webinar. This webinar is entitled How to Safeguard Your Business. I'm Alex Solo, I'm the co-founder of Sprintlaw. I am also a lawyer, a commercial lawyer, and we'll be going through in this session kind of like a general health check or a general summary of all of the different areas of law that you might want to, as a business owner or someone involved in running a business, want to be thinking about things like business structuring, intellectual property, contracts, IP, and more. Before we get into the content, just a little bit of an introduction to Sprintlaw for those who are not already Sprintlaw members or clients. We're an online law firm for startups and small businesses. Most of the work we do is fixed fee legal services. Traditional lawyers sort of charge by the hour, but our model is very much transparent pricing, upfront quotes. We have an optional membership, but about 90% of our clients sort of end up signing up to the membership, and it's a good service to kind of work with us on an ongoing basis as your lawyers. You can book in calls anytime for quick chats. You get discounts on our legal services, and there's some other software tools and things you can use for your business as well. A little more about us. We are a team of about 50 happy and rather progressive looking lawyers, as you can see from the picture. We have a bit over 6,000 clients, lots of positive reviews, won lots of industry awards, and we're actually in 3 countries. So Australia is our home, but also we launched in New Zealand last year and in the UK the year before as well. And so we are, I guess, a startup ourselves, and have kind of been on the journey of building a business from scratch and growing a team and all of those sorts of things, which definitely helps us in the way that we sort of advise all of our clients. So just into the content of today's session, as I mentioned, safeguarding your business, we're going to be covering a bunch of different areas of law that you want to be aware of, and making sure that you're at least turning your mind to these areas and thinking about how they might affect your business. So first, we'll start with business structures, why they're important. How is your business set up? What are some different kinds of ways it could be set up? Sole traders, partnerships, companies, multi-company structures. We'll look a little bit about at industry regulations, how they may affect your business. We'll spend a bit of time on contracts and terms and conditions, which we rather dramatically call the lifeblood of your business, and how you might think about them and where they might fit in. Intellectual property, we'll look at trademarks, copyright, confidential information, and look at how you can protect those. We'll touch on data and privacy, building a team, and at the end, we'll talk a little bit about financing and raising investment, which may be not applicable to all businesses, but those that are thinking of getting loans or equity investment. As I'm going through, do feel very free to drop questions along the way using the Q&A feature that we have in Zoom. I'll keep an eye on them, and I like to answer kind of as we're talking about the topic. We'll see if we get time. I think we've got about an hour for this webinar, so we'll see if we have some time for some more general Q&A at the end. But if you think of anything along the way, now is a good time to sort of drop it in and ask the questions. Before I go into each of those different subject matter areas, I just wanted to cover more of a conceptual question. When do you actually need to think about legal help? Because it's a lot of things that small businesses just don't think about. It's, doesn't come up in the everyday of your business, except in some limited circumstances when you're getting set up. It's not necessarily the case that you'll have a monthly appointment with your lawyer, or it's not super obvious in the day-to-day operations exactly when you might need the services of a lawyer. And a lot of the way that small businesses find out about what legal things they need to do is just anecdotally from other business owners, or, from family or friends. Oh, someone told me I need a trademark, or this contract looks rather legal. I better reach out to a lawyer. So it's rather ad hoc. It's not systematic. And I think the result of that approach to legal is that, there end up being gaps in your business, areas where you're exposed to legal risks and you only find out when something goes wrong. And it's always better to protect against problems rather than wait for them to happen. Now, that said, like anytime you put a lawyer in front of a client and you give them enough time, the lawyer will typically scare the client by telling them the 15-page list of every single legal risk that they need to manage, and so on and so forth. And small businesses, you don't have money to waste on legal services. You need to actually be generating revenue and sales. So I think it's also important, and certainly key to our approach, is helping you identify, well, look, there's a million things I can do, but what are the things right now when I have a limited budget that I should actually spend my money on? And so I've got this little matrix, which I think is a useful way of thinking about legal risk in your business. It's a fairly common risk matrix, but what you want to know is, okay, what are the legal risks for my business, of which there are many? And then of those risks, what are the ones that are negligible and unlikely versus the ones that are, if something goes wrong, potentially business ending and or very likely to occur? And the stuff that's sort of on the right side of this, higher risks or higher likelihood, that's the stuff you want to be spending your legal budget on. Once you become a larger organization, if that's where you end up, you might start spending money on the other kinds of risks when you can afford it. But if you have a limited budget, you just want to make sure that you're thinking about where the big risks are. And so I'll spend a bit of time as we go through focusing on what those areas might be, and also pointing out sometimes where there are risks, but they may not be so consequential. But I think it's useful to think about lawyers as sort of like risk management. You know, we're in a sense in a similar category to thinking about insurance for your business. You know, you're paying money to prevent against the risk of something going wrong. Now, it may be the case that nothing goes wrong, and you may feel like, well, why did I waste all this money investing in this protection? But ultimately, you're spending time, money, effort in growing your business, and you just want to make sure that if something goes wrong, you are protected, you can sleep at night. And the longer that you exist, the chances are it's more likely that, you know, one day something will go wrong with the client, or you may attract liability, et cetera, et cetera. So think of it as risk management. Think of it as a way to protect against risks, maybe in the same way that you think about insurance. And that's certainly one way to think about getting legal help. The second sort of lesser known use of lawyers, lesser known by smaller businesses, but very well known by larger businesses, is as a way to actually design better deals. So, you know, we're not just about protecting against risks. We can actually help you reduce your costs or increase your revenue if you use us as lawyers in a clever way. Really, an area this comes out in a lot is in contracts, and I'll talk about it in a bit more detail as we cover contracts. But you know, lawyers have seen all kinds of different types of agreements, and we can think often of creative ways to do business dealings, whether it's with suppliers or whether it's with customers or partners that you might not have thought of that may actually improve your business outcomes. For example, you know, we do a lot of work in the technology sector. We'll work for customers engaging app or software developers. If they don't seek a lawyer, they may just sign whatever contract the app developer gives them. If they do get our advice, we'll often help them negotiate those agreements, cover things like how to manage scope better, making sure that, you know, the app developers can't just charge you more and more and more, that you actually own the intellectual property and the work that they've done, and giving you ways to make sure that if there are errors or bugs with their work, they have to, for example, fix them for free rather than charging you more. So these are some ways that lawyers can advise you of common clauses that actually end up providing a return on investment. So do think of us as a useful resource for important deals as well, and not just about risk management. But I will say that in a lot of cases, you know, risk management is a way that you know, we sort of fit in. I've noticed Simon has put in a question about the difference between T's and C's, service agreement, master service agreement, which is a great question. I'll cover that one as we get through to the contract slide. So let's just kick off talking a little bit about business structures. I've got on this slide a fairly basic distinction between the sole trader business structure and the company business structure. For those of you who are thinking, I already know about this, this is too basic for me. Don't worry, at the next slide, I have a little bit more of a sophisticated look at some different business structures. But for those that are operating currently as a sole trader, one of the things you've probably heard that you might want to think about for your business is setting up a company. And I think this is a very big decision for people just starting out. You know, oftentimes you'll begin as an individual providing some services or goods to people. You know, you need a registration to operate a business, so you'll go online, set up an ABN for free, and you operate as a sole trader. And that can be fine when you're just getting started. But the risk of operating as a sole trader is that if something goes wrong in your business, you can be personally liable, you know, for issues. So you're providing services or goods to a client. Something goes wrong, they decide to sue you. As a sole trader, the law does not distinguish between you as a business person and you as an individual. This means that, if you suffer losses or liabilities, the person that's suing you is actually able to come after your personal assets, your house, your home, your guitars, your instruments, whatever it is, whatever assets of value that you may have, your car. These things are potentially on the line. And so for people operating businesses with any kind of risk attached or any kind of serious money involved, generally you speak to a lawyer, they say, look, if you're a sole trader, that's fine while it's a small scale thing. But as soon as this thing becomes serious, you really want to think about setting up a company. Now, it costs a bit more money to set up a company. It's about $600 to do it yourself, or I think around $1,000 if you do it with us or a professional service provider. But it costs money, and that's why people don't do it. But it is a significant benefit in terms of risk. So once you set up a company, you benefit from what we lawyers call limited liability. And what that means is your company is kind of like a separate legal person to you. It can go out, it can open bank accounts, it can sign contracts with people, it can do various things. It can generate its own liability, and it can be sued. And clients of the company or partners of the company can come after the company's assets. But the people behind the company, the people that own the company, the people that control the company, who are called shareholders and directors, those people and those individuals are generally, with some exceptions, not personally liable for issues in the company. Your assets are generally protected and limited by the assets of the company. So it's sort of like a shield between your personal life, if you will, and the life of your business. And that's why it's really a useful structure to set up, particularly when risk and liability comes in. It's also the most common structure for raising investment, for employing staff, and getting all kinds of government and tax benefits. So again, if you're a serious business, we really do recommend operating under the company structure. I haven't got on this slide the partnership structure. Partnerships are sort of like multiple sole traders working together. And again, in most cases, we recommend if you start as a partnership, think about moving to the company structure, because it's the same thing. Partners can be personally liable for issues that occur in the partnership. There are some industries, like my industry, the legal industry, where there's some requirements that you have to be a partnership. So you do see partnership structures out there. But again, in most cases, all lawyers will say set up the company structure. And for those wondering what shareholders and directors are, so shareholders are sort of like the owners of the fictional legal person that's your company, and directors are sort of like the controllers of the company. So the directors are kind of like the arms and the brain of the company. They can sign contracts, they can control the bank account, and the shareholders, I suppose, are sort of like the body. They will own the company, but they can't actually control it except through the directors who they'll choose, if that makes sense. So there's slightly different roles. In a small business, typically the founders of the small business are both the shareholders and the directors. So you don't see this distinction, but as businesses grow and get investment and so on, you start to sometimes see there be different shareholders and directors. And once they get much larger, that quite frequently happens. So hopefully that's a nice little overview of the difference between the sole trader and company structure. Got a question about a trust, which is a great transition to my next slide. So for those of you already operating under company structures, or who may have heard of the concept of dual company structures or trust structures, there are more sophisticated versions of company structures that you can set up. And certainly we would recommend these to people that can afford them, and certainly those that are operating kind of growing businesses. So on the left, you've got the single company structure, and that's the simplest form. You set up one company to run your business, and that company is sort of owned and controlled by usually the business owners and any investors. And that's a sort of better than sole trader way to run your business. You'd have all your assets in the company separate from the assets of the individuals. But for businesses that start to themselves own more valuable assets, hold more cash in their bank accounts, the idea of just protecting your personal assets may not be enough protection for actually what you want, because it may be the case that a lot of your key assets actually live in the company, and you don't want them to be at risk of potential losses when you're out there sort of running your business. So oftentimes we'll recommend businesses separate themselves into a dual company structure. They have a holding company, which will hold the business's intellectual property and potentially a lot of their cash. And then an operating company that'll go out and do business. It'll employ people, it'll sign contracts with people, it'll enter into leases, it'll do all sorts of risky day-to-day business things. Now, the advantage of this structure is that if your operating company that's out there doing all the risky things, signing contracts, suffers some form of loss, it means that even if this operating company gets sued, a lot of the crown jewels of the company, in fact, are stored in this other entity. And so you actually have double limited liability. You have liability of the holding company limited by the operating company. So people down here that are sort of doing business with operating company, in most cases, cannot come after the core assets of the holding company. And this means that if there is an issue with client number 600, of all the clients you've ever worked with, and something goes wrong, it doesn't necessarily mean the end of your business. It might mean the end of your operating company, but it doesn't mean that you couldn't set up another operating company and kind of continue to operate. So it is a very useful way to silo your risk. And also some larger organizations will set up multiple operating companies. They might have a leasing company, an employee company, and a customer contracting company, all ways to further put silos of risk around your business. So, if something goes wrong in one area, it doesn't affect the kind of whole. So Sprintlaw, for example, we have Sprintlaw Group Pty Ltd, our holding company that owns our brand name and a lot of our cash we've raised in investment. We have Sprintlaw Pty Ltd, our Australian company. We have Sprintlaw UK, Sprintlaw New Zealand, all separate operating companies. And we have Sprintlaw Tech that holds our software as well. So we've set up a multi-company structure, more than dual. And that's kind of how we silo all of our risk for different areas of our business. Definitely worth thinking about, particularly for growing companies and startups that might have raised capital, have some kind of important intellectual property. Again, costs more. You're going to maintain two companies, but can be a good way to manage risk. Finally, on the right, we have the trust structure. This is the more sophisticated structure. And you can see it in the bottom half, I've kind of got a dual company and trust structure depicted. The bottom half of this is the same. The way the companies operates is fairly similar, but the trust actually affects the top level, so the owners of the business in their personal capacity. So why might you set up a trust? Well, a trust is a way of holding your share ownership in a company. That's typically how it's used. There are other ways to use them to actually operate the business, but this is the most common way it's used in business. And so business owners will set up a trust to hold their shares. So in these examples on the right, we have founder one, founder two, kind of personally owning the shares in the company. But if you decide to hold your shares through your own company, you actually get two types of potential benefits. The first is you get another layer of potential risk protection. You get risk protection against other founders and investors, because in between you as the founder and sort of other shareholders, there's now a company that sits in between you. So that means that if the founders have a dispute, they may not again be able to come after the other founders' house, home, and assets. So we as lawyers don't mind them for an additional layer of risk protection. The second is that the trust structure has certain tax benefits in the way that you pull money or dividends or profits out of your company, or if your company is eventually sold, in the way that the funds flow from your shareholding to you as owners. If you have a trust structure, there can be certain tax advantages in the way that those funds are ultimately received or dispersed by you. And those tax advantages can be quite significant. And oftentimes founders who have used the trust structure end up basically with a much more tax effective income stream coming from the business rather than those that are holding it in their personal capacity. So for those interested in the trust structure, probably something to discuss with your accountant. It kind of blends your personal life with your business life. And it may be that you use your trust to hold your property, and you do things with your family as well as you use it to hold your shares in the business. But in most cases, people find it to be an effective structure. And again, at Sprintlaw, I'm one of the founders. I hold my shares through a trust. I mean, we have this structure on the right. So my co-founder and I both have trust to hold our shares. Some of our investors have trusts as well. And we have these holding and operating companies. So this is sort of the gold standard structure. It's a bit expensive. There's 4 companies to maintain and additional tax requirements, but definitely worth considering if you're particularly running a sort of growing business. Just moving through to the next section, regulations. So once you've got your business structure sorted, I won't spend too long on this, but one area of law that everyone should turn their minds to are regulations or laws that might apply in your industry. So what these regulations are, to some extent, depend on exactly what industry you're in. We as Sprintlaw operate in the legal industry. There's regulations that govern how we can do our marketing, how we can present ourselves. If you work in hospitality, there's regulations around how, what kind of standards you must comply with in terms of food safety. If you operate in the childcare sector, there's regulations about how you must operate your childcare practice and so on. So each industry has its own set of regulations. It's quite important for you to be aware of what your industry's regulations are and make sure that you're complying with those regulations in the way that you operate your business. This is something actually that typically lawyers, can help you with, but would recommend that you, as the business owners or business runners, are across yourselves. Most industries will have their own regulators, and they'll have their own resources and guidance and advice. And a lot of the ways that you need to comply with your regulations come down to the way that you need to operate your business. So as lawyers, we can give you a letter of advice that tells you, here are the various things that you need to be aware of. But ultimately, to make it stick, you're going to have to change the way your operations work. You might change the way your marketing works, your hiring works, or change the equipment that you use in your business. So if it's an area that you're not fully across, and again, a lot of business owners are already across this, definitely have a look at your industry, do a little bit of research online, and make sure you're aware of any regulations that apply to the kind of work that you do, and think about them in your business model and any changes you might need to make to your procedures and processes. Now, in addition to industry-specific regulations, there are a couple of kind of Australia-wide regulations that apply to most small businesses. Probably the most well-known one is the Australian Consumer Laws, and it has a bunch of sort of regulations about how you can interact with your customers, circumstances where you must offer refunds if you don't provide quality services, ways that you can market yourselves in a way that isn't misleading or deceptive, and these sorts of things. So for those that aren't aware of the Australian Consumer Laws, again, another thing, pretty much every business has to comply with them. There are some changes coming up in November. We're running another webinar on that, which make the consequences of not complying with them much more severe than they have been. You can get fines and penalties and those sorts of things. It's not super hard to comply with them. You just need to be very clear in the way that you represent your terms to your customers, and make sure you're not too one-sided in the kind of dealings that you do, but definitely worth doing a little bit of research on that area as well, the Australian Consumer Laws. So that's sort of all I wanted to touch on regulations. So now let's talk about contracts. This is, I think, the area that most people are interested in, and really we have this rather dramatic title, Contracts are the Lifeblood of Your Business, just to kind of emphasize the importance of contracts in all sort of areas of your business. So I've got on screen the most common types of contracts, commercial contracts that you may be dealing with in your business operations. I've left off employment contracts here because we have another slide talking about staffing. So these are more contracts with external contracts with sort of third parties. So on the right, we have the contract between your business, represented as a house, and your customers. So this is typically, for most businesses, your most important contract. A lot of the work that Sprintlaw does is helping people with their customer agreements, and what these customer agreements are called is kind of up to you and varies from industry to industry. If you're a graphic designer, it might be your graphic design service agreement. If you're a tradesperson, it might be your business terms and conditions. If you're a IT vendor, it might be an IT services agreement. All of these documents are relatively similar. They're what we call as a category customer agreements. And to answer, I think, Simon's question earlier, what's the difference between terms and conditions and a service agreement or master service agreement? These are all different types of customer agreements. Really, the names don't matter that much. It's kind of what you want to call it. And what you decide to call it depends on how you're presenting your business to your customers. A service agreement and a terms and conditions can kind of be the same thing. The only difference is a terms and conditions typically implies that it will be accepted by a sort of tick box or not a formal signature. A service agreement typically implies there'll be a signature. But from a legal perspective, the content of those documents may be very similar. And a master service agreement typically implies that it's going to cover ongoing services over a long period of time. And you may have specific quotes and things that happen. And all of those quotes will be governed by a single sort of master agreement, if that makes sense. But really, when we draft terms and conditions service agreement, master services agreement, 90% of the clauses are the same, because ultimately they're all about your relationship with customers. And so what needs to go in these customer agreements? Well, there's really kind of three key areas that we focus on. One is liability. Every day you're dealing with customers. What if something goes wrong? Yes, most of the time it's fine, but what if I do something wrong that causes my customer loss? What you want to make sure is you've got liability clauses in there, which limit your liability and don't make it business ending if something goes wrong. Typically, what we'll do is we'll say, hey, look, I'm going to provide you with these goods or services, customer, but if things go wrong, the maximum that you can sue me for is just a refund of the fees you've paid me, or 2 times a refund of the fees you've paid me. You can't sue me for every little penny that you've lost that flows on from the mistake that I made. So that basic risk protection is something that we'll spend a lot of time on for a lot of our customer agreements. Sometimes there'll have to be exceptions because your customers won't accept that. If you're really negligent or you lead to a cyber incident or whatever it is, customers might expect you to have some more liability in some cases. But one of the key components of these customer agreements is protecting you as the business from liability for risks if things go wrong. And we'll typically spend time when we draft these agreements drafting various disclaimers and those sorts of things, which are effective legally. So for example, an easy one to understand is a cleaning business. We might put in the liability clause, we, the cleaners, will, clean your commercial or residential property. But if we accidentally break $1 million vase, or, we break a window on your expensive sports car, the maximum you can sue us for is a refund of the cleaning fees. We're not going to be liable for the entire cost of your car, because that will put us out of business as a cleaner. So these kinds of things are what can go in these client agreements. But in addition to those things, you can also put in scope and fee clauses, which are very, very important for making sure that your revenue streams are secured and that you're making sure that what you're offering, whether it's a good or a service, is relatively clear to your customer and they can't sort of push the scope beyond what they've paid for. So again, we'll spend a lot of time clarifying that, the services or goods are, limited to XYZ features. If you want features that do not align with them, additional fees may be payable. We will do our best to make sure they're of XYZ quality, but we don't promise that they'll be the most amazing thing of all time. And the specifics of the wording of those things will depend on what your service or product that you're offering is, but very important, so that if there's issues with customers, you're on the same page and you say, well, look, per our agreement, this is kind of what we agreed to deliver for the fee, and that's what you agreed to, and this is just how we work. And it can be a really effective way to make sure you don't end up providing goods or services for free because customers were under false pretenses as to how things work. So very effective to have clauses around that stuff set out. And then payment, of course, I think really matters a lot in terms of if your customers are promising to pay you money at a certain time, you want that in writing, you want that signed. If they don't pay on time, you might want to charge them interest and give them some incentive to actually pay you. And if you end up, it's a significant sum, you may want to take some form of action against them as well. So having that in writing in your customer agreement is really important. And finally, there's things like termination clauses and cancellations and these sorts of things. So a lot of components to these. I think for people out there that haven't had a lawyer drafted customer agreement, if there's one thing you invest in, that and trademarks, as I'll come to, I think those are probably the big two. But certainly in the contracts that I'm about to cover, the customer agreement is the most important. It's your core document. You're probably using it every day, and you just want to make sure that you invest in getting it right once, and you can potentially use it as a template for all of your customers as well. So that's, I guess, one of the most important agreements. The other kinds of agreements you might come into contact with are on the other side, supplier or service provider agreements where you are the customer and to sort of their business. And so typically they're going to be giving you their standard agreement. In some cases, they might have been drafted by Sprintlaw. And if you actually read through them, probably they're all set up to protect them from risk and liability and those sorts of things. Now, equally, when you're the service provider or the supplier, you might want to protect your business. You don't want to protect your service provider or supplier's businesses. You want to protect your own interests. So you may actually want to change their agreements. You may want to say, look, I'm engaging you as a service provider. You're pretending you're not going to be liable for anything. But if you do X, Y, and Z thing, I want you to stand behind it. I don't want just a refund from you if something goes wrong. I actually want you to have more liability. So you might actually negotiate the liability clauses of your service provider agreements. You might negotiate the payment clauses. You might negotiate the refunds, the rectification clauses, and these sorts of things. If you just sign what you're given, chances are, you're selling yourself short in some way. So these agreements, a lot of businesses will just sign what they're given from their suppliers or their service providers. coming back to my kind of opening slide, if you got lawyers to look at every single one of your supplier agreements, I'm sure we'd find things that could be better in them. Of course, in reality, most small businesses don't have the money to have every contract reviewed, and we're kind of aware of that. So what you want to be thinking about, particularly with these supplier or service provider agreements, one of the most important and expensive agreements that I'm entering into, if you're a goods provider, maybe it's your wholesaler's agreement, the person that provides you with most of the goods that you need to on-sell to customers. If there's delays or issues with the orders, you want to make sure that there's consequences, that you get discounts or refunds or some kind of compensation because it's going to affect your business. So those agreements you might want to have checked. If you've got someone developing software, an application for you, which if it goes down, it presents a real business risk, that may be a case where you want to actually have that contract looked at. If you've got someone coming in to do, a couple of $100 job, promoting a campaign for you or something, unless there's significant risk, maybe that agreement isn't worth checking. But certainly for your key service provider and supplier agreements, do think about having them checked, because if you don't, chances are it protects them and not you. And there's a lot of opportunity to improve your position here, both from a risk management perspective, but also from, as I mentioned earlier, getting a better deal. Finally, we got partners. Again, a lot of businesses will have referral relationships with other businesses, or co-selling or other sorts of relationships. Those things oftentimes are done through, we have an image of a handshake on screen, handshake agreements, and not sort of formalized through an agreement. And that can be fine. It may not be necessary if it's all based on good faith to actually formalize a relationship. If no one's ever going to really sue each other, there's not many risks, and it's just kind of warm introductions, you may not need something. But if you have significant partnerships that start to become a really key part of your business, and again, your livelihood or revenue depends upon it, your staffing for your partners and those sorts of things, as you start to get towards that end of the spectrum, it can be a good idea to formalize those partner relationships with contracts. Again, if it's an important source of revenue for you or an important source of your business, you might want to have some clarity around how things work. What happens if the partner wants to change from you to a competitor? Is there exclusivity? Are you giving them better prices because they're agreeing to give you a certain amount of volume, et cetera, et cetera? Are there commissions payable and these sorts of things? So definitely a case where you may want to consider putting contracts in place. Just going to have a quick check through some of the questions, because it looks like we've got a couple on contracts. So first from Josh, if things go pear-shaped with the contract that Sprintlaw implements, will we help after things go pear-shaped, e.g. the app developer contract? So we can help sort of with the early stages of a dispute that happens under an agreement. We can help interpret what the agreement says, tell you kind of what your risk position is, and give you some practical steps to kind of resolve the dispute. If the dispute progresses towards a litigation where someone wants to sue somebody or someone's threatening to take you to court, we'll typically refer you to one of our litigation partners. People that deal with courtrooms and things like that are a little more specialized in that area. I would say that most agreements, particularly small business agreements, don't end up in court. They're often resolved amicably through some sort of settlement between the parties. And we can help with those kind of early stages at Sprintlaw. So oftentimes it's just a matter of understanding what the contract says and what your risks are. And then, once you know that, you can go back fully armed and say to the person that's threatening you with legal action, look, I've spoken to lawyers, here's my position, this is what I'm going to do. And oftentimes will help with that kind of level of support. So hopefully that answers that question. Dan, if I get my wife to do marketing work for my company, should I have an employee contract with her? She has a part-time job with another company. Yeah, I guess that's a sort of bit specific to your circumstances. Look, I think it kind of depends on a few factors. If it's just your own proprietary limited company, just only you and no one else is kind of involved, the only advantage of really having the contract in place is generally, to make sure that intellectual property is passed to your company, that it's quite clear what payment is, and those sorts of things. There's not necessarily a legal requirement to have an employee contract, so it's more of a risk management decision. Of course, things can go wrong, marriages break down and those sorts of things. So if you choose not to, you're just absorbing those risks. But there's not a piece of law that says that you must have an employment contract. It's just generally recommended by lawyers in nearly all cases. Now, you also mentioned having a part-time job with another company. One risk probably for your wife in that circumstance is a lot of employment contracts may say you can't do other work on the side without our approval. So that's something that probably you might want to get checked. If it's a part-time job, maybe it's okay. But yeah, no legal requirement explicitly that you always have to have an employment contract, but it's a good idea for risk management. So it kind of will end up being up to you based on your circumstances. Danux asked, I guess, a related question: is mandatory to have business liability insurance in case you get sued? Not mandatory, except in specific industries. Like, for example, lawyers must have professional liability insurance under law, but a lot of other industries, there's no requirement. It's not mandatory. It is a good idea. It doesn't cost that much. And just like having a nice contract and a company structure that protects you against risk, insurance is another great way to have an additional layer of protection, so another shield in cases of risk as well. So we generally suggest that all of our clients consider getting some form of insurance specific to what they provide. Again, we're in the business of risk management, so if you don't want to get it, you kind of are saving the money, but you've got the risks there. And finally, Simon, how would I include scope in a customer agreement when the scoping is the first part of commencing the work? Yes, excellent question. So this is where, to your earlier question about having a master service agreement structure, this is why people often go with the master service agreement structure, which, like I said, these agreements are all pretty much the same, but master service agreement will typically imply that we, the lawyers, will set up a document for you that's quite non-specific. It will just set out liability terms, payment terms, and various other risk management clauses. And then we'll usually give you a template, like a form that you can fill in. And that form will have the name of the customer. It will have the pricing. It will have any other customer-specific clauses that you change from job to job. And what you can then do is, without having to speak to lawyers every time, engage a customer, fill out the cover page form yourself, and then attach the full form agreement that we've given, and you do that on a day-to-day basis, and you can kind of reuse the contract as a template. So typically, yeah, there's a kind of cover page, or what some people call a scope of work, or an order form, or a cover page, doesn't really matter. But again, some kind of commercial component to the document that you fill in from customer to customer, and then the longer form customer agreement sitting at the back, which can be called potentially a master services agreement. Fantastic. Just moving through now to intellectual property. So this is another one of the key areas people are often wondering about. How do I protect the intellectual property in my business? So before we get into the different types, what is intellectual property? What does the term mean? As the name suggests, it refers to property of an intellectual form. Another way of thinking about it may be intangible property. So you've got physical property, goods, things you can touch and feel, real estate, and then you have intellectual property. So ideas, creations, brands, these sorts of things are the domain of intellectual property. And these things, while conceptual, can be very, very important to a business's inherent value. And as such, you're going to want to protect them. So there's kind of 4 main types that we think small businesses should think about. 4.5, depending on how you classify them. We've got trademarks and designs, copyright, NDAs, non-disclosure agreements, confidential information, that sort of thing, and then patents or patents, depending on whether you're, I think, British or American, depending on how you want to pronounce it. So people have probably heard of all these different areas. I've kind of got them in order of importance generally for small businesses. So I'll spend most of the time on the first 2, trademarks and copyright. So trademarks are a form of intellectual property protection that's intended to protect your brand name, your logo, your business name, and potentially a catchphrase or something like that you might have for your business. When you get a trademark for those things, you will have the exclusive right to use those elements of your brand in your industry in a particular country. So to bring that to life a little bit more, Sprintlaw, if I go back to our cover slide, we own a trademark for the word Sprintlaw. We have a trademark for this little S-shaped logo thing. And I think we also have a trademark for one of our catchphrases, which is business legals made simple. So what that means is, and I should say we have that registered in Australia, in the UK, and New Zealand, and a couple of other countries we're hoping to expand to in the future. And in each of those countries, it's registered in the legal class, so class 45, it's called in Australia. So what that means is no one else in Australia or those other countries we're in can use the word Sprintlaw or anything deceptively similar to it, Sprint Lawyer, Sprint Legal, in the legal industry in association with goods and services. They can write news articles about us, of course, but they cannot promote a brand using that word Sprintlaw. Nor can they do something using something that looks like this S shape, even if they're called something else, amazing law. But if they have this little S shape, then again, if it's in the legal industry and representation with goods and services, we have the exclusive right to that. We can give them a cease and desist. We can sue them for trading off our goodwill. We have a monopoly for a period of our registration, which is usually about 10 years, to this kind of brand. Now, I should be very clear, this is limited to the legal industry. If someone starts a cafe called Sprintlaw that serves amazing coleslaw, I don't know if it's a very good name, but if they did that, they could do that potentially because they're not in the legal industry, so they're not necessarily trading off our goodwill. If someone in the legal industry wants to use something like this in association with goods and services, we could stop them from doing so. Now, it's very important to mention that trademarks are not the same as registering a business name. So anyone that would have set up a business, probably all of you here, whether you're a sole trader or a company, would have chosen a name for your business when you set up your ABN or ACN. Maybe you've got a name for your PTY Ltd company. That's fine. That's a registration requirement. You can choose whatever name you want as long as no one has an identical match. That's not the same as a trademark. That doesn't mean you own the brand. There could be another company out there that's using the name of your business as a product name, right? But if they've registered a trademark for it, even though you got your registration through, they can come out there and cease and desist you from using that name in association with your goods and services. So this is a really, really common mistake. I did an article recently where I went back through, I think, all the 60,000 kind of legal inquiries and jobs that we've done and looked at the most common legal mistake we've seen. And it's this failure to get a trademark, which really does cause a lot more issues than you would expect. So if you don't have one, my public service announcement is definitely consider getting one. If you're investing time, money, and energy in building and growing your brand, you want to make sure you own it. You don't want to find out that someone else owns it when you start to get a little bit of traction and forces you to change your name and logo and all these sorts of things. You just want to make sure you secure it. It can take up to 7 months to get it fully secured, sometimes a bit longer. So just make sure you secure it as early as possible. As lawyers, when we set up the business, we do things in a particular order of what we think are important legally. Number one, we set up a company. Number two, we got a trademark. Those were the first two things we did when we got set up because we wanted to make sure before we launched as Sprintlaw that we really owned that name. So definitely look into that if you haven't already. There's something as well called designs. It's a similar registration process to trademarks where you can register a design. A design is like a furniture design or a design of a product shape or those sorts of things. A bit niche to people that work in product industries, but if you do work in one of those industries, again, you can get a monopoly over a particular design, own it, and then no one else can copy that design. So it's a good way to secure that kind of IP. So brands and then product designs, that's what we have in this first category. The next category is copyright. Again, a lot of people would have heard of copyright. Copyright refers to any piece of original work that's recorded in material form. And once that exists, that definition is met, copyright has appeared. So again, to bring that to life more, there's a few elements to it. You have to create an original work. So there is a legal definition of originality, which is somewhat mysterious, but it refers to something that hasn't really been done before and it has some element of novelty. And then it has to be recorded in material form. So just because you have an idea, the second you have that idea, that doesn't mean there's copyright in that idea. It has to be recorded in material form. It has to be in a business plan, or you have to have created a design or drawing or artwork or piece of music or whatever it is. There's no copyright in ideas. We need this material form requirement. Now, people often associate copyright with like music and movies and film and books, and certainly all those things meet that criteria. When you write a book, if it's original and it's written down, you've ticked the boxes, there's copyright in the book. But it can apply in many cases in business. I mean, this presentation, I would argue it's original. You may disagree, but I think it's reasonably original. It's recorded in material form, which is this PowerPoint presentation. The second it was created, it was owned by me as the author of the copyright. And so that's an important point. Where these trademarks and designs get registered in Australia with a organization called IP Australia, copyright is not registered. It doesn't need to be registered. It is owned by the author the second they create it. It's automatic. So as I said, when I created this presentation, I owned it the second it was created. Now, as a business, you're going to have important presentations, maybe procedure documents. Maybe you're going to have, pictures, artworks. If you have software code, that's, if it's original, potentially covered by copyright. Any of these things your business may have, the second the author of those things created, it's owned by them. And you want to make sure that it's not owned by them, but it's owned by your company, your fictional legal person, because you want to use it without restriction. You don't want the authors owning all of the things. So typically in employment agreements and other forms of contracts, there will be clauses that say, while you work for my company, you, the employee, anything you create in the course of your employment will be automatically, upon creation, assigned or transferred to my proprietary limited company. So again, coming back to the example, whilst I am a founder and director of Sprintlaw, I'm also an employee of Sprintlaw. So under my employment contract with Sprintlaw, the second that I created this presentation, I theoretically owned it for a split second, but under my employment contract, it got transferred to Sprintlaw Pty Ltd. So employment contracts are a very important way for businesses to make sure they own the intellectual property of work that their employees do, and it sits within the business. It's theirs. The people can't take it and steal it and use it and start other businesses. Similarly, an often missed area is in your contracts with your service providers or suppliers or contractors who aren't signing your employment agreements. If they're developing stuff for you, graphics, websites, any other form of potential copyright, by default, they own it. So you want to check these agreements and make sure that it has that same clause that will be in your employment agreements. When you create something for me, it's transferred to me, I own it, or I at least have the right to use it, if that makes sense. So the main takeaway for this copyright stuff is you want to own these original material form things that are relevant to your business. By default, they're owned by the creators. And what you want to try and do is make sure you've got contracts in place that transfer them to you. And that's the way that you can secure the copyright in your business. Just noticed Simon's got a question that looks like it touches on copyright, so I'll have a look at it. So we want to license all of our creative work rather than sell them so the client cannot edit them or use them. Is that copyright? Our clients also only license the edited work, not all the raw footage captured and used to create the final work. So yes, that is the domain of copyright. So it sounds like you work in maybe marketing or video space. So I guess you're a service provider, or in this case, you're this business and you may have a customer. So there's two ways this stuff can work, right? And this is where the contract comes in. The second that you create the footage, as the creator of the footage, if you're capturing footage for a client, as the creator of that footage, you will own the copyright in those original creations. Even if you're capturing footage of other people, typically the footage is owned by the photographer or videographer or person capturing the footage. And then, if I was your customer, I might want, as I was just saying here, I might say, hey, well, I want to own all the copyright and the stuff that you've created because I want to use it however I want. And you may say, well, too bad, because that's going to cost you extra money. Under our standard agreement, we charge you a fairly reasonable license fee, or it's fairly reasonable fee, and that only gives you the right or a license to use it, but we still own it and we can do what we want with the raw footage. And you are only getting the rights for this fee to a subset of the footage which we've edited. And that's fairly common in the creative industries to not actually give up copyright ownership. So you can certainly structure things that way. All of this stuff, because there's no registration for copyright, is just covered in the copyright clauses of your client agreements, and they will specify how this stuff works. And it can be an important part of your business model if that's kind of how you want to operate. So hopefully that addresses that question. We've got NDAs and patents. NDAs refer to confidential information. So, I said before, there's no copyright in ideas, but sometimes there are amazing ideas that you want to protect. There's business opportunities that you've discovered, or just ideas for businesses. Because those ideas, the second you think of them, don't have any legal protection, oftentimes before you tell people about them, you just want to make sure they're secured. So lawyers would recommend you get NDAs in place before you tell people secrets that may not be quite copyright. Get them to sign a document which says, you may tell me some stuff. I promise not to tell anyone. If I do tell somebody, you can sort of sue me for breach of NDA. So NDAs are an important way to protect those forms of ideas and intellectual property that don't quite constitute copyright and aren't really like your brand name and so on. And they're a good catch-all for just really using a contract to protect something that's valuable. I mean, we generally will suggest most businesses just have a standard NDA that they can roll out and get people to sign before sharing information. And it's a good little tool to have to help protect your business. Finally, patents. These are not super relevant to most small businesses unless you're working in pharmaceuticals or robotics. These are inventions. That kind of push forward human progress and that are highly, highly original. So copyright has a definition of originality, which is fairly low threshold. Patents, to get one, it has to be like no one before has ever published anything about this in like any academic journal anywhere in the world. I have created something amazing, like when Edison created the light bulb or whatever it is. So those sorts of things you can actually go register a patent for. Costs a lot of money, but once you register it, you get an exclusive right to use that actual product you've created, which gives you a monopoly over it. And if any competitor tries to use the same invention or use part of your invention, you can sue them for patent infringement. So it's a very, very common way that people who've invented vaccines or drugs and things protect their creations. Not a lot of small businesses think they might be able to patent their software or an app they've created or whatever it is. It's possible, but pretty rare that it would meet the test for patentability. So, it's pretty rare that we do this stuff for small businesses, but I thought useful to mention in case people thought that they might have something patentable. And if you're ever in doubt, you can always just have a chat to a patent attorney who can usually tell you in 10 seconds whether you've got an invention that might meet the test or not. Conscious I've chewed up a bunch of time going through some of the other areas, which I hope people have found valuable, but I'm going to kind of still try and cover a few of the other areas. We might go over a little bit by 5 to 10 minutes. For those that need to drop off at one, feel free to, and we'll kind of circulate the recording afterwards. So you can catch up on what you missed. So just continuing into data and privacy. So this is an area that, oh, sorry, I noticed Lloyd just asked a copyright question, which may be worth answering. Can you copyright a t-shirt design and slogan? Yes, you can. You can actually trademark the design and slogan, potentially, depending on what it is. And there's also copyright in the design and slogan the second it's created. So when a t-shirt design is created, the author of that design, if it's original recorded in material form, will own the copyright in that design. And then potentially you could try and trademark it as kind of like a logo or brand stamp sort of thing. So you can get copyright and trademark protection on that design. And then a slogan typically isn't, it's possible if it's a very original slogan that there will be copyright in it, but typically if you want to protect a slogan, you go down the trademark route where you literally can register slogans. Like I said, Business Legal's Made Simple. Our slogan is registered as a trademark. So yeah, trademark is probably the way to go to protect those things. But also the author will own copyright in at least the design when it's created. So I hope that makes some sense. So just going into data and privacy, this is an area that's gotten a lot of media coverage lately with, I guess, the Medibank and Optus stuff that happened in Australia. And there's some legal changes that have been rolled out in the last 3 to 6 months, talking a lot about how businesses are going to need to comply more with privacy laws, including small businesses, and directors of companies may start to have obligations to keep customer data safe, or as an exception to what we covered earlier, where you're personally protected. It's now being suggested that directors of companies may actually have, in these kind of rare circumstances, personal liability if they're very negligent around data and privacy, which is quite a significant potential change to the way our legal system works. So long story short, this is an area that people need to start taking seriously because there's laws coming into place that you need to comply with around privacy. I won't go into them in great detail now, but suffice to say, in Australia, we have the Australian Privacy Principles for businesses above $3 million in revenue, or businesses that really trade in specific types of health information. There's requirements that you have to comply with in terms of having a privacy policy, in terms of letting people know what you're doing with their information when you collect it, and making sure you have consent to use their information for various purposes, whether it's marketing, email communications, or just even holding it on file. And you have to, for example, if they request access to their personal information or details about what you're doing with it, you generally have to comply with those requests and have to have systems and procedures to know where in all of your systems their personal information is. So something we suggest all businesses set up is a basic privacy policy and a couple of basic procedural documents internally. And that will often get you a lot of the way there to some basic privacy compliance. I mentioned the GDPR here. It's actually not an Australian law. It's a European and UK law covering privacy, but it has a global impact. So if you have customers in those regions, you've actually got to comply with two sets of laws, the Australian laws and the GDPR. And the GDPR is a little bit more stringent. It requires you to have cookie pop-ups and a few more things in your policy documents and a few more procedures in place as well. So anyone that's collecting personal information, which is most businesses, because you'll be collecting your customers' names, address, and emails, make sure you've at least got a privacy policy in place and have a little bit of a think about your procedures for handling personal information. Do you know where your customer's information is? And are you taking steps to secure it from unauthorized use? And do you know what your privacy policy says? And can you actually comply with the clauses within it? These are some steps that you need to follow to comply with the privacy laws. On the right-hand side, we have data breaches and cybersecurity. In the event something goes wrong, there's a data breach of your business, you get hacked, someone steals all of your customers' data and leaks it. There's now laws which require you in some cases to report the incident to the privacy regulator, and also to have notifications ready to go to send out to your customers who are affected to say, hey, I'm sorry to let you know, but your data has been breached. Failure to tell customers when there's been a breach can result in fines and penalties from the regulator. And so a lot of our clients are setting up these things called data breach response plans. So they're kind of ready to go if there's a data incident so they can comply with their legal requirements. And cybersecurity is kind of in the same bucket, but not really legal so much, but just, in addition to these legal protections, just worth making sure you have some form of cyber insurance and some sort of investment in cybersecurity, because these things are becoming more and more common, and making sure you're protected against these risks, I think, is smart for pretty much any business. Simon's asked, where would a privacy policy be deployed? Seeing it on a website, but elsewhere. Look, yeah, typically people put it on their website and then reference it in other documents like their customer agreement. Really, under the law in Australia, every time you collect someone's personal information, you should be giving them a link, an easy to access link to your policy, which explains what you're doing with it. So on your contacts forms, there should be a little reference to it. If you collect information in person, you should either attach your privacy policy or make it really easy for them to actually view it when they're there. It's the requirement is when you collect information, customers must be told what's being done with it. So it's about, it can be stored on your website, but in terms of being deployed, referenced next to every kind of personal information collection form is the best practice. We'll quickly cover getting into building a team. So for those of you that have employees or are thinking about having employees in the future, there's a few considerations. We kind of have three categories of staff that you might put on in your business. We've got employees, we've got contractors, we've got interns. Each of them have slightly different legal requirements. The one requirement common to all of them is, as I've kind of been harping on about, good idea to have a contract in place with all of them, just to make sure you own the intellectual property. It's clear how payment and those sorts of things work, and how termination may work, and other sorts of things. In the case of employees, in addition to having an employment contract, there's laws that apply to how you must treat and kind of manage your employees, work health and safety laws, of course, but also minimum wage laws, which are done on an industry level through these things called industry awards. So you can't employ and pay people at below certain minimum wage rates. And then requirements around annual leave, sick leave, managing tax obligations, and these sorts of things. So when you're taking on employees, where lawyers fit in is we'll often help you with the contracts. And then oftentimes you can engage a bookkeeper or payroll support provider that can help you with a lot of the other obligations around tax, superannuation, and those kinds of things. And it's important for yourself to be aware of what the minimum wage laws are in your industry, just to make sure when you're hiring people, you're complying with all those obligations and so on and so forth. Employment is very much about contracts and then some compliance steps that you need to take. Contractors are a little more flexible. Contractors are, in a sense, a separate business to yours. They're people that you will employ to work for you, but not on an employment basis where they work and pay and have various forms of job security, but rather they are being used usually for a specific job or on an ad hoc or occasional basis. Typically, there'll be a contract between you and them, and maybe a day rate, and maybe fixed fee. It can be whatever the contract says. You don't have to necessarily comply with any specific laws around minimum wages and these sorts of things. They are required to take care of their own taxation, and in most cases, with some exceptions, their own superannuation. A lot simpler administratively. As a result, contractors often cost more and charge more because they're not having all that stuff taken care of. And typically they'll be working for multiple clients who may have sort of less loyalty for your business. But a lot of people will use contractors as a more flexible workforce. And once they have steady work, will begin to use casual or more permanent employees. So contractors are, again, mostly about the contract, making sure that it's clear, robust, covers how payment works, intellectual property ownership, termination, these kinds of things, but less in the way of compliance obligations and minimum wage laws to worry about. And finally, we have interns. I've noticed Hugo's asked a question, can we reuse our standard employment contract for interns? So internships can be paid or unpaid. I think unpaid, there are laws around unpaid internships because people have used it to get free labor before without good justification. So one thing to check with interns as a threshold is if you're not going to pay them, does it meet the requirements for a legal internship, which is generally around it being valuable work experience and kind of limited in time. To the extent that it's unpaid, to your question, Hugo, we would generally recommend no. We would say use a different kind of agreement. We call an internship or work experience agreement because it will have disclaimers in there around how it's genuine work experience and help in complying with those unpaid internship laws. If it's a paid internship and really they're just like a employee for a fixed period, as long as you have a flexible standard employment contract where you can put a start and end date in and those sorts of things, it would in those cases often be fine to use your standard employment contract if payments involved, because then it's not really in this unpaid internship category. Again, with interns, similar to employees, there's contracts, there's compliance in place, and there's this extra law around genuine work experience, it's called. So if you're taking on interns, just make sure you're aware of those things before hiring people. And we're now through to the final slide, getting financing. So the last area I wanted to cover, and this is more tailored towards businesses that are thinking of raising or obtaining external financing. A question, of course, is how does this stuff work, and what is the legal side of sort of securing financing? Well, I have on screen, I guess, what are the 5 most common types of financing that we see smaller businesses obtain. The first is equity financing, and this is particularly for startups, what they call raising capital. Equity financing is when you sell a portion or an ownership stake in your company to an investor. So they become a kind of co-owner or an owner of the shares in your organization. They're typically not directors, although in some cases they may be. Oftentimes they're just a shareholder who will own a portion of it, and maybe they own 10%. They're therefore entitled to 10%. In most cases, 10% of the profits of the company, and or 10% of the sale value of the company if it's sold in the future. So it's a way investors make big returns through share investment, and it's a way your business can obtain some financing in order to invest in its own growth. So that's equity financing. Debt financing, most people would know what that is by name, but that's getting a loan of some description. You can get loans from banks, from kind of private lenders, or from individual lenders, family and friend lenders. Loans are fairly straightforward in terms of from a legal perspective. There's usually just a loan agreement which sets out how much money is being loaned and when it has to be repaid by, and what the interest rates are. In some cases, loans will be secured, which means that if the lendee fails to repay the lendor, the lender will be able to take ownership of some kind of asset, whether that's a piece of property or real estate, or maybe the assets of the business if it has some inventory and stock. And that's very good for the lender to help secure their loan and may often bring down the interest rate. So for businesses seeking debt funding, typically they'll organize that with a bank, at which point there's not much room for lawyers because banks very rarely will negotiate their loan agreements, although we can help you understand what they say. Or businesses will take a private loan out from a venture lender or some other private lender, at which point, the most important thing is getting the contract right, making it clear when payments are due, what happens if payments aren't made, how security works if there is one, and so on and so forth. We have this third category called convertibles and safes. So this is a category of funding which is somewhere between equity and debt and is very, very commonly used by startups to raise investment. You can think of these almost as early bird tickets to equity fundraise. So you'll raise money from an investor. You won't yet give them a percentage stake in your company as you would in an equity financing. But what you'll say to them is, look, we are a startup business. We are intending to raise a few $1 million from a big investor in a year or two's time. We want to take some investment now, but we don't know what percentage to give you yet because we don't really know what we're worth. We're just a small company that just started. So why don't you give us some money? We can start spending it. And then in the future, when we eventually decide to raise more significant investment, your investment that you made right now will turn into an ownership stake in our company, and it'll come in at the same terms as these future larger investors come in at, but with a little bit of a discount, so like an early bird discount, if that makes sense. So you'll pay 10% less on the price per share paid by those future investors. So it's a fairly common way for companies to sell an ownership stake. The big thing with selling an ownership stake, of course, is that you have to define what the value of your company is, because if someone gives you $100,000, are you worth $1 million? Are you worth $5 million? Are you worth $10 million? It's not a public stock market for small businesses, so you don't know what you're valued at. So you will often just be deciding what you're valued at. Maybe you'll get an independent valuation, or in many cases, it'll just be an agreement between you and an investor as to what you're valued at. And oftentimes convertibles are used to push back the need to have that conversation about what a business is valued at to a future point. That gives you a bit of a sense of how these documents work. As I said, early bird tickets to an equity investment is a good way to think about them. There's something called a safe note, which is very popular with startups now, which is a particularly short document that makes raising smaller amounts of capital very, very easy. And we do a lot of these for our clients as well. The fourth category is crowdfunding. And this is where businesses can sort of raise from a crowd of individuals. You can do reward-based crowdfunding or something like Kickstarter, where you might just pre-sell a product and not give up any ownership in your company, at which time it's fairly straightforward. The platform will typically have terms and conditions and allow you to sort of pre-sell products in exchange for funds. And as long as you meet the orders that you promised on the platform, it's all generally straightforward. There's a new form of crowdfunding called equity crowdfunding, or crowdsourced financing, as the Australian regulations call it. It's a way actually for businesses using a platform. There's a couple out there, Virtual on Market are two that we work closely with, where you can actually raise investment if you don't know any investors that want to loan to you or invest equity or convertibles in you. You can post your business on one of these platforms and raise from a ton of micro equity investors who will own a little stake in your business. So it's a new form of funding. It's becoming more and more popular with small businesses. And we often will work with the platforms. The legals can be fairly sophisticated and probably not worth going into now. But the good thing is when you work with one of these platforms like Virtual or On Market, they'll often take care of a lot of that stuff for you. And, we as lawyers will work with them and help you through the process of raising funding. And so you end up not having to research all of this stuff yourself because it's kind of part of the package. But for those interested, best to just reach out to the platforms and have a chat to them and learn a bit more about how they work. But seems to be doing quite well, particularly in the last year. We've seen a big uptick in smaller companies doing this equity crowdfunding. And finally, we have grants. there are all kinds of government grants. If you don't have a grant advisor, not a bad idea to have a chat to one. There's plenty out there. If you work in tech, there's R&D grants, which can give you a significant rebate on your investment in software development, or if you work in the science industries as well, and you're designing something innovative, again, potential for you to get significant rebates on your investment. There's MVP grants. I think it's not too difficult for startup companies to get, I think something like 20 to 25,000 from various state governments for startup capital, if you have an original business and a good business plan. And there's more substantive grants for businesses exporting, the Export Market Development Grant, as well as a number of other industry-specific ones. So definitely worth going out there and having a look at grants, even if you can't, from a quick Google, find the grants that may be applicable to your business. Advisors are typically good at finding things that you might fit into. At Sprintlaw, we've gotten a number of grants over the years, and it's been really helpful in our funding journey. I mean, we've raised grant funding, convertible financing, debt, and equity. So we've used a lot of these on our journey at various points. And it's a good idea to think about mixing them as your business kind of grows. So we went a little bit over, but thank you for those that stuck around. That is the end of the legal content from this presentation. I hope you found this useful. Follow us on Eventbrite or LinkedIn if you want to come to more of these. We're going to start doing these monthly. Next month, we're going to be focusing on this big change to unfair contract terms that affects most small businesses. So do come along to that. We'll circulate some details. Any follow-up questions or feedback would be much appreciated. But it's been real fun. Thank you all so much. I'll see you later.